Today's presentation will be about the International Criminal Court. We will look at when, where, and why the court was founded, the scope and jurisdiction of the court, how the court works, and then we will examine some cases, both closed and ongoing, to see how the court functions. Most crimes that take place on a day-to-day basis fall under the jurisdiction of a clearly defined legal entity. If a local or state level crime happens, that legal entity takes care of it within the system of that country. However, there are some crimes that are so large and far reaching that it is not clear who or how they can be prosecuted. This is why the ICC was formed, to investigate, prosecute, and try individuals accused of committing the most serious and heinous crimes known to man, such as genocide, crimes against humanity, war crimes, and crimes of aggression. The road to the ICC was a long time in the making. After World War II, the world had witnessed some of the most terrible crimes ever committed. In response, the UN created a treaty known as the UN Assembly Convention on the Prevention of and Punishment of the Crime of Genocide. This was the first international effort to push back against the crime of genocide and was ratified unanimously by all members of the UN. The treaty was pushed to the back burner as the Cold War raged and internal delays stalled progress. However, this would not remain stagnant forever, as the atrocities committed in Rwanda and in the Balkans reignited international efforts to curb genocide. Both the tribunals of Rwanda and the Balkans would further lay the groundwork for the ICC. From June 15th to the 17th of July, 1998, a conference of over 160 states and over 200 non-governmental organizations met in Rome to establish the first permanent international criminal court via an international treaty known as the Rome Statute of the International Criminal Court. The Rome Statute was approved by 120 nations, with 7 nations, including the United States, that voted against the treaty. Following the Rome negotiations, a preparatory committee known as PrepCom was tasked with creating the rules and procedures and evidence, the elements of crimes, the relationship agreement between the court and the United Nations, the financial regulations, and the agreement on the privileges and immunities of the ICC. On 11 April 2002, PrepCom's work was ratified and the treaty entered into force on July 1st, 2002. The ICC has a very clearly defined jurisdiction and scope. The ICC is a permanent and autonomous entity, which makes it different from a tribunal, which is temporary and also not an appendage of the UN, as it is an independent body. The ICC can only intervene when a state is unable or unwilling to prosecute, meaning that the ICC will never step on the toes of another government who is prosecuting an individual, because if they are able to prosecute that individual, it is outside of the ICC's jurisdiction. The ICC has jurisdiction in states that submit to the court, i.e., have signed the Rome Statute and ratified it, in other countries where crimes were committed by nationals of a state, party, or country that have submitted to the ICC, and in states where an instance was referred by the UN Security Council. The ICC has jurisdiction regarding events which occurred after the statute's entry into force on 1 July 2002, meaning that the ICC cannot retroactively persecute or try individuals for crimes committed before the 1 July 2002 cutoff. The ICC prosecutes individuals, not groups, which makes it different from the International Court of Justice, or states who have engaged in genocide, crimes against humanity, war crimes, and the crime of aggression. The structure of the ICC is clearly defined as well between the divisions of the presidency, pretrial chambers, trial chambers, appeals chambers, office of the prosecutor, and the registry. 18 total judges make up the amount of judges that sit on the ICC. Judges are elected by the assembly of the state's parties based on their established reputation and track record within the legal system. Judges have expertise on a specific issue or a few issues. The ICC has a fair representation of men and women and an equitable geographical distribution amongst judges. Each judge is from a different country that has ratified the Rome Statute to keep trials as impartial as possible. The presidency is comprised of one president and two vice presidents, who are ICC judges and elected by a supermajority of the 18 sitting ICC justices to act as the administrative arm of the ICC. The pretrial chambers exist to provide oversight before a case is admitted to the ICC to protect individual rights, issue warrants and summonses, and to confirm criminal charges. The trial chambers exist to try people once they have made it through the pretrial process. Once arrested, the presidency allocates a trial chamber to that case. The trial chamber's goal is to conduct a fast and fair trial with the full respect of rights of the accused and the safety of victims and witnesses. The trial chamber determines whether an accused is innocent or guilty of the charge or charges. With a guilty verdict, the court could impose a sentence of imprisonment not exceeding a maximum of 30 years or life imprisonment, financial penalties, reparations for the victims including compensation, restitution, and rehabilitation. The appeals chamber is comprised of the president of the court and 4 other judges. All parties to the trial may appeal or seek to leave to appeal decisions of the pretrial and trial chambers. The appeals chamber may uphold, reverse, or amend the decisions appealed, and may revise a final judgment of a conviction or sentence. The office of the prosecutor is an independent organ of the court tasked with receiving and analyzing information on situations within the jurisdiction of the ICC. The office of the prosecutor determines whether it is reasonable to launch a formal investigation into the matters that are analyzed. This office is divided into 3 divisions to fulfill the defined duties of the office. First, the investigation division, which is responsible for conducting investigations. Second, the prosecution division, responsible for litigation. And 3, the jurisdiction complementary and cooperation division, responsible for determining the admissibility of cases. The registry is responsible for defense, victims, communication, and security matters. This office makes sure the court is properly serviced and effectively assists victims, witnesses, and the defense to protect the rights guaranteed under the Rome Statute and the rules of procedure and evidence. The types of cases that the ICC addresses are also clearly defined. As previously stated, the ICC exists to take on some of the most terrible crimes committed by humanity, specifically genocide, war crimes, crimes against humanity, and crimes of aggression. The ICC has clearly defined definitions for each one of these international crimes. The targeting of a group, known as genocide, is defined by the ICC as killing members of a group, causing seriously bodily or mental harm to members of that group, deliberately inflicting on a group conditions of life calculated to bring about its physical destruction in the whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. The ICC can charge a person with crimes against humanity for some or all of the tenets listed under what qualifies as a crime against humanity, including murder, extermination, enslavement, deportation or forcible transfer of a population, imprisonment, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity. persecution against an identifiable group on political, racial, national, ethnic, cultural, religious, or gender grounds, enforced disappearance of persons, the crime of apartheid, and other inhumane acts of a similar character, intentionally causing great suffering or serious bodily or mental injury. Individuals may be charged of war crimes if they violate international laws against how to conduct themselves during a war. This may include murder, malnutrition, cruel treatment and torture, taking of hostages, intentionally directing attacks against civilian populations, intentionally directing attacks against buildings dedicated to religion, education, art, science, or charitable purposes, historical monuments, or hospitals, pillaging, rape, sexual slavery, forced pregnancy, or any other form of sexual violence, and conscripting or enlisting children under the age of 15 years into armed forces or groups, or using them to participate actively in hostilities. This would include such activities as using chemical weapons, or having child soldiers, or bombing a civilian population, such as the United States did in World War II, along with the British in Dresden. The crime of aggression is the newest addition to the crimes that one can be guilty of committing and was adopted by the Assembly of States Parties during the review conference of the Rome Statute held in Uganda between 31 May and 11 June 2010. As defined by the ICC, a crime of aggression includes the planning, perpetration, initiation, or execution of an act of using the armed force of a state against sovereign territorial integrity or political independence of another state. The act of aggression includes, but is not limited to, invasion, military occupation, annexation using force, blockade of the ports or coast, if it is considered a violation of the UN Charter. The perpetrators of the acts of aggression is a person who is in a position effectively to exercise control over or to direct the political or military action of the state. The ICC's jurisdiction over aggression was activated on 17 July 2018 and March 2022. 43 state parties have ratified the crime of aggression to the Rome Statute. To illustrate how the ICC works, let's take a look at some settled court cases that the ICC has adjudicated. First, we'll start with the interesting case of the prosecutor versus Jean-Pierre Bemba. Jean-Pierre Bemba was the president and commander-in-chief of the movement de Libération du Congo, which is known as the MCL militia group in the Congo. He had a warrant for his arrest issued 10 June 2008. He was charged with 2 counts of crimes against humanity, murder and rape, and 3 counts of war crimes, murder, rape, and pillaging, allegedly committed between 2002 and 2003. The ICC Trial Chamber Number 3 declared Jean-Pierre Bemba guilty of war crimes and crimes against humanity in 2016. However, what makes this a really interesting case is that the ICC Appeals Chamber acquitted Mr. Bemba on charges of war crimes and crimes against humanity in 2018 due to insufficient evidence. The checks and balances of the ICC allowed Bemba to not be prosecuted and serve out the sentence that he was originally charged with. So the oversight of this court, I have come to find out, is quite immaculate, and people do not get convicted of things that they did not do. Another case that illustrates how well the oversight of the ICC works is the case of Abdullah al-Sanusi, and in the Gaddafi case, in the case of the prosecutor versus Saif al-Islam Gaddafi. Abdullah was the colonel of the Libyan armed forces and the head of the military intelligence at the time of his arrest warrant. His warrant was issued on 27 June 2011. He was charged with 2 counts of crimes against humanity allegedly committed in 2011 in Libya. Case against al-Sanusi declared inadmissible before the ICC on 11 October 2013 due to national proceedings in Libya regarding the same crimes. So at the same time in Libya that he was going to be charged by the ICC or tried by the ICC, he was being tried back home in Libya for the same exact crime. So instead of continuing their investigation and trial, the ICC got rid of it and they let Libya take care of it, because one of the core tenets of the ICC is that their jurisdiction is only over prosecuting cases that are that a jurisdiction cannot or will not prosecute. So since they were prosecuting at home, they kicked it back to Libya, where he was sentenced to death in 2015. Case of the prosecutor versus Almaty is a little bit more clear-cut of a case than the last two. He was allegedly a member of the Ansar ad-Din, which is a group associated with Al-Qaeda, and the head of Hezbollah until September of 2012. His arrest warrant was issued on the 28th of September 2015. Almaty was accused of committing war crimes by intentionally directing attacks against religious and historic buildings in Timbuktu, Mali, in June and July of 2012. During his prosecution, he ended up pleading guilty to the charges they leveled against him, and he was sentenced to 9 years imprisonment on the 27th of September 2016. However, on the 25th of November 2021, Almaty's imprisonment sentence was reduced by 2 years, and he is set to be released on September 18th, 2022, which is coming up rather rapidly. Now to look at some ongoing cases that are being taken care of by the ICC. So Al-Hassan's case is related to Almaty's case. It took place in the same time frame, in the same area, with the same groups as Almaty in Timbuktu, Mali, where they attacked the different types of religious and historic buildings. However, he is charged additionally with crimes against the civilian population, where he submitted the population to torture, rape, sexual slavery, and other inhumane acts, including inter alia, forced marriage, persecution, and war crimes. His warrant was issued on the 27th of March 2018. On the 23rd of April 2020, Pre-Trial Chamber 1 partially granted the prosecutor's request to modify the charges against Mr. Al-Hassan. The trial opened on the 14th and 15th of July 2020. The trial resumed because of COVID. There was a pause on the 8th of September 2020. And 52 oral witnesses were called by the prosecution. On May 9th of 2022, the defense made its opening statements, and the presentation of the evidence of the defense is currently ongoing. So you can really see right now at this ongoing case how the court system works. Pre-trial, the prosecutor had their investigations going on. It went from investigation to pre-trial. Pre-trial confirmed the crimes, and then those crimes are now being tried in a court of law. In the case of the prosecutor versus Ali Muhammad Ali Abda al-Rahman, this case relates to the atrocities that have been taking place in Darfur, Sudan. Ali Muhammad was allegedly the leader of the Janjaweed at the time of his warrant, 27 April 2007, and of his other warrant, 11 June 2020. His charges include suspicion of 31 counts of war crimes and crimes against humanity allegedly committed in Darfur. On the 9th of July 2021, the pretrial Chamber 2 confirmed all the charges of war crimes and crimes against humanity brought by the prosecutor against Ali and committed him to trial. On the 5th of April 2022, the trial in this case opened before the trial Chamber 1 and is currently ongoing. Given the nature of these crimes and how connected he seems to be, I would have to guess that he's going to be charged with all of the crimes that are leveled against him, but it's hard to say right now exactly if he did all of those things or what the court will exactly do. But the process is carrying out as planned. One of the more recent cases to enter into the jurisdiction of the ICC is the case of the prosecutor versus Alpha Yekatom and Patrice Edouard Nagasayan. Sorry if I butchered that name completely. Both men fell into custody in late 2018. Both men are accused of a laundry list of crimes, including crimes against humanity of murder, deportation or forcible transfer of a population, imprisonment, or other severe deprivation of physical liberty, torture, persecution, and other inhumane acts, and war crimes that include murder, torture, and cruel treatment, malnutrition, intentional attack against the civilian population, intentional attack against buildings dedicated to religion, enlistment of children under the age of 15, and used to participate actively in hostilities, displacement of civilian populations, and destruction of the adversary's property. Pre-trial has concluded and the prosecution has started presenting its evidence, and testimonies of prosecution witnesses are ongoing. So this one is just getting started, really. I imagine that this case will take at least another year probably to get fully worked out. I don't know if they're going to try to appeal it, but yeah, this one looks like it's pretty bad, and I think they'll be able to get some of this stuff to stick. I'd hope they get at least a couple out of all of the things that have been leveled against them. In conclusion, the ICC has done some really incredible work in the limited amount of time that it has existed on this planet. It works judiciously, fairly quickly for the type of international body that it is, and as demonstrated with some of the settled cases already, the oversight of this committee is impeccable. I don't think any person or member of a nation has to worry about being wrongly prosecuted by the ICC. They're very, very judicious and very particular about what charges they level against people and how they handle themselves. Um, During our trip to The Hague, where we visited the ICC, I had never really experienced some place that felt so professional and so willing to help out populations of people that they had never met before. I got to sit in for a brief moment on a trial that was ongoing regarding Darfur. I found the judges when I was there to be immaculately qualified, not just based on the resumes that I was able to procure, but based on how they conducted themselves and the seriousness of everything and how they took care of the identity of the victims and how they allowed their testimonies to come through in the trial without jeopardizing their identity. I think the ICC does some very, very important work and they do it very well. So I'm looking forward to the betterment of this institution and what they bring to the table in the future.